Welcome to our second Stuff Business Live chat. I'm Susan Edmonds, and today I'm joined by Alistair Espy, who's an employment lawyer with Duncan Cotterill. We'll be taking your employment law questions. You can submit them somewhere down below here, and we'll work through as many as we can. So welcome. Thanks for being with me today.
Thanks, Susan. Great to be here.
My first question I have for you is, can an essential business force staff to come to work during lockdown if they're not sick?
So the short answer is they can expect staff to come to work, at least staff that are part of performing the essential service. So you will have some employees potentially who are not necessary in that regard. The question becomes a bit curlier though when you have employees who say, look, we don't want to come in. And then it's a question of, is there a reasonable ground for refusing? And further, is that employee entitled to be paid or not?
That was going to be my next question. Can you expect to be paid if you're not working?
Well, I mean, I guess in terms of whether you have a reasonable ground to decline to work, an obvious example would be, for example, if you're immunocompromised or you're at a high risk of COVID impacting upon you or your family, and particularly where you've had medical advice to that effect. So in those sort of circumstances, generally you'll have a reasonable ground to decline to work. Now, as for whether you're entitled to be paid, it'll probably depend on the contract or whether you can reach agreement with your employer. But one of the options you'll also have there will be for your employer to go and apply for the short-term the COVID leave support payment there, which is essentially another variation on the wage subsidy. But that captures those sorts of employees who can't work for having a heightened risk of COVID. Now, if you don't have those kind of reasons, you just simply don't want to go into work because while there's a Delta outbreak, it's obviously scary. That might not necessarily constitute a reasonable ground, at least compared to those people that have those particular medical conditions. So in those circumstances, again, it's probably a matter of trying to reach agreement with your employer. Ideally, the employer should do what they can to put you at ease so that you can come into the workplace, and if there's extra precautions that could be taken and so forth. But look, if you can't reach agreement with the employer, then potentially you're in a situation where you're not going to be entitled to be paid.
Okay. I've heard from a lot of people who aren't big fans of working from home. If you are working for a non-essential business, can you be told that you must work from home?
Well, if there's work to be performed and your role can be performed from home, then again, it's one of those scenarios where, look, the employer can reasonably expect you to carry on performing your role to the extent you can. Where it does become tricky is particularly when people have commitments at home that mean that, for example, if they've got children to look after and can't really dedicate their time to work, that's a scenario where, look, ideally the employer should be as accommodating as they can of that, and options might be reduced hours, flexible start and finish times. And you do hear a lot of sort of people doing shifts, particularly where both partners are working. So those sort of options are all there. But again, look, if there's work to be performed, but you can't perform it, then if you decline, that's your right, but at the same time, you may not have an entitlement to being paid through that.
Okay, all right. I've had quite a few people ask me about annual leave. Can an employer tell you that you need to take your annual leave if the business has to close?
So in the short term, the answer is generally no. Where an employee has annual leave, and you did see this come out a lot last year, where employers said, look, we want you to take annual leave. The position is that you can only really be forced to take it. You can only take it in the short term by agreement. So the employer could ask its workforce and say, look, are you prepared to take leave? And if employees say yes, then great. But if not, then the only way an employee could be forced to take leave is if they're given 14 days clear notice of that.
All right. Someone also emailed me last night and said last time she was able to top up her wage subsidy payment with leave, and this time her employer said no. Can they tell you not to take leave?
Well, at the end of the day, employers are entitled to decline a request to take leave. And I think you do have a lot of employers who take the view that, leave is for rest and recreation. And I guess depending on who you are, lockdown may or may not tick that box. But look, if an employer doesn't want to approve a request for an employee to take leave, they don't have to. But it will be one of those situations where if an employee is not otherwise going to be paid, it would be quite tough to decline that type of request.
Yeah, okay. A lot of businesses have been in touch as well saying that they just can't pay their staff their normal wages at the moment. If they're going to need to reduce the workers' pay, what do they have to do that, I guess?
Yeah, well, this kind of touches on one of the really curly questions. And I guess the starting point here is always going to be what is the employee entitled to in the first instance? And that will depend on, in a lot, the specific circumstances. But generally, there's kind of two groups of employees. There's those who can work either because they're essential and can go on site, or there's those who could work from home. Now, in the first category, the starting point will generally be that you're entitled to full pay. There will be exceptions to that for various reasons and so forth, but generally that will be the starting point. Where it becomes curlier is in the case of employees who can't work from home, and simply because their role can only be performed on site. And there have been comments certainly made in the media at times by various commentators suggesting that this is cut and dried. And one argument is that, look, it's full pay still, and anything less requires agreement. But where I guess the other side, and the employment profession itself, is fairly split on this, and there's no clear court decision that resolves it. The other side of the argument is, look, the contract simply can't be performed. The employee in that case is not able to leave home to do the role, so they're not really willing and able to work and not entitled to pay. So that potentially is your starting points. Now, if you do have an employee that's entitled to pay, then to reduce it, you are going to require agreement. And one of the mistakes a lot of employers have made is to treat receiving the subsidy as basically a grounds to automatically reduce it. So the position will always be that, look, if an employee is entitled to full pay, then you need to go out to them, propose the reduction. It might be just a reduction in pay. It might be a reduction in pay in hours. Ideally, set that out for them in writing, though a conversation would always be advised as well. And then to give them a chance to consider that request, and then ideally take advice and come back with their decision. Now, if the employee says, look, they're not agreeable to it, then you can't unilaterally reduce the pay. From there, you'd have to look at alternatives, and potentially, if you need to cut costs, that might mean restructuring.
Okay, I see. That kind of leads to the next question that we had, and was, is there a minimum amount that workers need to be paid during the lockdown period?
Yeah, so like in those scenarios I said before, again, if you're working from home, generally it'll be full pay unless there's some very specific circumstances, or an exception that could apply there. Otherwise, if you're not working from home, again, that's the big question. Is the minimum amount full pay, or is the minimum amount no pay? But then obviously, even if you have no contractual entitlement to pay because you can't work during lockdown, if your employer is receiving the wage subsidy, then the minimum amount will still be at least the subsidy, but ideally topped up to 80% if the employer can manage that.
Okay. I had an email last night from a man whose daughter works 20 hours a week normally, but her contract only has 3 hours set out. And so during this period when she's not been able to work, she's only been paid for the 3 rather than the 20 that she would normally work. How should that work?
Well, it's a tricky one because it probably depends on how normal, because sometimes normal might just be an average of so forth. And from there, generally speaking, I think you would look to the pattern of hours there, what the employer is regularly working. So if in reality it is 20 hours consistently over an extended period of time, then there will be an argument that should be the baseline for pay. But again, that comes back to that point before. Look, if it's a role that can't be performed at all from home during a lockdown, then there might be an argument that theoretically nothing is owed.
Yeah, this was a retail job, so I guess, yeah, nothing you could do at home, probably. Okay, another question was, I was meant to start a new job during the lockdown. Should I be getting paid already for my new job?
So if the contract sort of was supposed to kick in during the lockdown, then technically your employment started, and the terms of the contract apply. Same scenario as I said before. Potentially there's a distinction based on if you could do the role during lockdown or if you can't. If you are able to do the role, then generally speaking, the employer should have either allowed you to start, or if they can't provide you with work, then unless there's some unique circumstances, probably would need to pay you through that period.
Okay. Right, here's another one. Can an employer ask you to sign an OK to shift the annual pay review forward 4 months from the date in one's employment contract? If you don't sign, do you still have to be reviewed on the original date in the contract? And is it okay for them to say, we did a review, there are no pay increases for anyone? Essentially, no review and no pay increases.
Yeah, well, it's like the pay reduction thing. So the employer can ask the question, and if you've got the right in your contract to review at a set time, you don't have to agree to a change there. In terms of having a right to say we've done the review and no increase. Look, you will find probably with most employment agreements they tend to have wording that says, we will review your pay annually, but this does not guarantee a pay increase. So generally that would probably address the question. But even if it doesn't, there's not necessarily an absolute right to have an increased pay unless your employer has done or said something to you that makes it a foregone conclusion, or they have a policy that guarantees that they need to comply with.
Okay. Can an employer make you take annual leave during lockdown instead of paying the wage subsidy? The employer has received the wage subsidy.
So like I said before, they couldn't make you take annual leave inside 14 days. Potentially you could be directed if the employers tried to reach agreement in the first instance, and then you couldn't. They could say, look, you have to take some of your annual leave after 14 days. So maybe there. But even if you are taking annual leave, the wage subsidy would still be put towards that. So, the employer's obligation, no matter what, is to pay the full wage subsidy to an employee. So if they're saying take annual leave and are not paying you the wage subsidy, then they're probably in breach of the subsidy obligations.
Okay. How much flexibility do you think that people should expect from their employer if they're juggling, kids trying to homeschool and work and keep everything afloat?
You would hope there would be a reasonable amount of flexibility. I mean, for us in Auckland, this is our 5th time in lockdown, and for everyone else, it's at least the second. So, we've all kind of had a go at this kind of system of working from home, and you would hope that I think most employers can recognise that, look, it will work generally, but you may need to sort of give some flexibility to make that happen. So, look, that would be the ideal scenario. Sometimes there may not be an ability to afford flexibility, particularly when certain sort of appointments need to be fixed in at set times or so forth. So, if the circumstances don't allow, then look, that may well be the case. But look, if there is an employer who could grant flexibility that probably isn't, the employee could potentially look at a flexible working arrangement request under the Employment Relations Act, but that probably isn't really going to help in the immediate short term. So it's one of those things where, I think I'd encourage all employers to try and be as flexible as you can. And it should only really be if you can't make something work that you have to say no.
Okay. This is another question from a reader. I made myself redundant from our travel company last year, but then things started to pick up. This year, I came back to work on the 1st of May, working 5 days a week, but not paying myself any wage or salary. Can I claim the wage subsidy?
Well, it's an interesting one because potentially you could claim the wage subsidy, but you wouldn't be able to pay yourself it because, this comes back to the wage subsidy scheme is designed so that no one ends up getting more than they would normally be earning. And I think last year there might have been some paper boys, for example, who actually went under the old rules. They didn't quite have that clear position, who kind of came to the system a touch by actually getting a significant increase on their normal paper run pay. But in this case here, look, if you weren't really earning any income before we went into lockdown, and assuming you're self-employed, then you wouldn't actually have any normal pay that you could use the wage subsidy for. So if you claimed it, you couldn't pay it to yourself, and in all likelihood, you just end up paying it back.
Yeah, okay. Would you expect employers to be helping out with any of the work from home expenses that people might be encountering at the moment?
Potentially. I mean, again, I think employers should be making reasonable efforts to facilitate people working from home. That said, generally people will have power and internet at home. So those are things that employers wouldn't necessarily be expected to provide. But, if the lockdown, particularly if it drags on for longer than 2 weeks for Auckland, and certainly if it goes beyond 4 weeks, it's a case where, well, your home workplace is not really just a short-term thing at that stage. So legally an employer may not be required to, but it is certainly something that could be considered.
Okay. Are they taking on any kind of health and safety risk having staff at home? Do we need to check that everyone's got ergonomic chairs or anything like that?
Yeah. Well, look, I mean, home is the workplace for the time being. The employer's obligations don't cease just because an employee is working from home. So, generally an employer should at a minimum be checking with employees just to make sure that their setup is appropriate, and that may mean sort of setting up staff checklists to run through to make sure that your computers are set at appropriate heights. In terms of ergonomic chairs, it practically might be a little hard to roll them out in the middle of a lockdown, and it's certainly hard to get someone around to do a full-blown occupational assessment, which you might see in the workplace.
Yeah.
But they should do what they can, and I think that's the physical side of it. The other part that the employers really should be quite mindful of is the mental side as well, because health and safety extends not just to physical risks, mental risks as well. So lockdown is particularly stressful, and can particularly when there's pay issues coming into play and that sort of thing. So it is one of the things that employers should also be mindful to really check in. And that again goes to that discussion we had before about flexibility. It's one of those things where, look, for the sake of your employees' mental health, you may need to give them more flexibility and certainly more slack in terms of what is expected of them during the lockdown.
Yeah. If staff weren't performing during this time, would you expect employers to go through a normal kind of performance management process, or should we be sitting it out and waiting for things to get back to normal?
Yeah, it's one of those ones that always depends on the facts. Like, I think, it's reasonable to expect that generally people may not be as productive. The monotony of getting out of bed, walking to your office and that being your day can sort of, take a toll. So I think there does need to be an allowance made for it. But, if you have a serious underperformance issue where it's something that probably isn't just explained by lockdown, then it's one of those things that, look, reasonably you could still address it. And at a minimum, have an informal sort of check-in and catch up with the employee, and only really if it's more serious, or potentially if it's something that was already in train before the lockdown, would you be looking at starting or continuing a formal process.
Okay, all right. I have another question from a reader. I was instructed by my doctor to have a COVID test. I did so, but was unable to attend my workplace until a negative test result was received, which took 3 days. I have not been paid my wages for this time off and have been told I must use my sick leave, as that is why the annual entitlements were raised from 5 to 10 days. Is that correct?
Yeah, so I think, look, it probably more often than not, and assuming this test was because you may have been showing, say, COVID symptoms, if your doctor advised you to do it, then there's probably an argument that if you're unwell, then it is appropriate for your employer to suggest to you to use sick leave. It is a scenario where you're not able to work, assuming it's a role you can't do from home, so there wouldn't be the normal pay entitlements. But there is the option that the government's rolled out of its short-term absence payment, which is essentially for a scenario where you've been advised to take a COVID test and need to stay from home awaiting the result. So there is strict criteria. Just because you wanted a COVID test and decided to go and get one yourself won't necessarily cut it. But if you're in the case where you've been advised by the ministry to go and get a COVID test, or your doctor has recommended that you do so, then your employer would be entitled to a $359 payment that they would then get. And look, if you're taking leave, it would just be part of the leave payment. But if you haven't got any leave available, it means you at least get something through that period.
Okay, all right. Another reader says, last year, due to the length of lockdown, there were income relief payments for staff who lost their jobs. The lockdown came at a bad time for us, and it's looking like I will need to let staff go. Is there any discussion around that relief payment starting again in Auckland? I saw that Grant Robertson said that it was something they'd thought about, but it wasn't, happening immediately.
Yeah, I haven't heard any more than that.
Yeah, what support would there be for people?
Well, I think last year it was almost, and I forget the amount of the payment because it keeps changing all the time, but there was essentially a scheme where if you lost your job for redundancy, as a result of COVID, then you could seek relief, which was, I think, for an certain length of time, following employment, maybe 10 weeks.
That's right, 12 weeks.
12 weeks, yeah. So potentially they would look at something like that. But it's interesting because this kind of lockdown, I haven't seen anywhere near the level of restructuring that you saw, at least in terms of clients I've been working with, that we saw the first time around. And it's also just interesting because I think in the first lockdown, particularly the very first level 4 one we had last year, it was 2 to 3 weeks of just wall-to-wall COVID queries, wage issues, restructure issues, and in fairness, a lot to get your head around because it's the first time we've done it. This time we're still seeing the COVID queries, the wage issues popping up, and the ones that we still don't have clarity on 18 months into the whole thing, and other questions around vaccinations and so forth. But at the same time, we're still seeing so much more business as usual, employers just going about their normal processes with employees or sort of queries that might have otherwise been put on hold during previous lockdowns.
Okay.
So, and I think that is a case of a lot of employers are just sort of getting on with it to a degree where they can, and consistent with that, we're not seeing the sort of panic that brought about all the restructures and redundancies the first round did. So that's not to say it won't happen, particularly if it carries on, but it's not been as big a factor this time around, at least from what we've seen.
No, that's positive. What process would someone have to go through if they realise that they couldn't make it through and they needed to let some staff go at the moment?
So I guess just the first thing to keep in mind is if you're getting the wage subsidy, you're obligated to keep your staff for the full period. So if you got the initial 2-week one, then you couldn't make anyone redundant during that period. And if you're getting the extension, which I think would be open from Friday for another 2 weeks, then the same deal. But if you do need to look at redundancies, and it may be that you even if you're getting the subsidy, you might not be able to sort of hang on to people in the long run, then you would still need to go through the usual process of consultation. So that would mean putting together a change proposal that sets out, broadly, what's your current structure for your business, and what are you putting in place, which roles are impacted, what's the reasons for it, and then give it out to your staff and give them a chance to consider it, take advice, come back with your feedback, and then make a decision on whether or not you need to go through. And look, some restructures are more complicated than others. In certain cases, it might just be straightforward. In other ones, you might have to go through a selection process to decide actually at the end of it, if we are going to reduce the number of roles, which roles go, or which employees go if they're all doing the same role. So there's different processes based on the particular circumstances, but the key thing is consultation. Make sure you roll out a proposal to staff, seek their feedback. Don't just tell them they're redundant, because that's not going to go down well.
And can you run that process remotely if you are still in level 4? Say?
Yeah, and we did see that a lot during the first lockdown last year. I think the key thing to keep in mind is that if you are going to run those processes remotely, you should still, wherever you can, try and speak to your workforce. So in a normal restructure process, you might have individual or group meetings. So, if you can try and do that through Microsoft Teams or Zoom or something like that, try and bring that into your process. And the other thing would just be to give staff a bit more slack. So, time frame, unless you're facing an imminent collapse or something like that, you should be a bit more flexible in terms of your time frames, giving people perhaps a bit longer if they need it to come back and give their feedback, and especially in the current sort of time when employment lawyers and advocates and so forth are all still working, but there's a lot of work going on, so it sometimes might take a bit longer to get the advice that they need. So it's just keeping that in mind. But yeah, the short point is that yes, you can run the process.
Okay. Someone's asked about vaccines. Can an employer force an employee to have the vaccination? It's a retail environment, not an essential worker.
Yeah, so it's an interesting one because obviously the places where vaccination is clear cut is on the border, for example, where the government has released orders that say you have to be vaccinated to do these roles. Everywhere else, it's a question of the employer kind of undertaking and deciding, well, is there a particular health and safety risk? And it's fair to say there isn't actually this really clear guidance on it. I do think, particularly in heightened alert levels, the risk to retailers or to customer-facing roles is a lot higher. So there may be an argument there, but in saying that, I don't think you can necessarily roll out a requirement to be vaccinated and then say if you're not vaccinated, you're not working now, given the level of vaccination we're currently at. So it's arguable, but I think right now it would be difficult to justify it, even when we are at level 4 in Auckland and level 3 the rest of the country.
I think I saw the minister saying that you could make it a condition of a new employment contract. Is that right?
Yeah, so you have a lot more scope when you're hiring staff. So, with your existing staff, you're going to need that health and safety justification, not just to require vaccinations, but also to ask the question. To say, well, are you vaccinated or not? Because the question will be, well, why do you need to know? Before employment, when you're talking about a role, you do have a lot more scope, and you don't necessarily need to have that kind of health and safety justification to make vaccination a contractual condition of employment. So you will be able to put that out in a lot more circumstances. The one exception, though, that you probably would need to keep in mind is that if you did have an employee who had applied for a role and due to a medical condition couldn't be vaccinated or had been told it was higher risk, then you would potentially need to look at sort of making an exception for them, because if you didn't, you would run the risk of having a discrimination claim on the basis of physical disability. So, that would be a scenario where if you encounter it, you'd need to wait. Well, actually, do we then have a health and safety reason for acquiring vaccinations? Again, it can't just be, there's COVID in the community and everyone in New Zealand's at risk. But do we have a heightened risk? And then the next question would be, well, could we manage that risk? And are there other ways to ensure an unvaccinated worker and the others around them are safe? And if you can do it, then you're probably going to need to make the exception. If you can't, then that would be where potentially you'd have grounds to still say no.
Okay. Another question come in. I'm not sure that this is one for you, but it says, my brother's a lawn mowing contractor and he wants to know if he can operate at level 3. Where can they find that sort of information?
I think I can't answer that one off the cuff, sorry. So I'd say probably go to the COVID-19 website, which has all the guidance on which businesses can operate. But I think, in fairness, it's a question a lot of businesses are probably asking right now, and it's the key thing for anyone who is potentially not been able to work at level 4 and now could.
Okay. Should a 2-team group of workers who, under normal conditions, all work as one, still be separated at level 3?
Look, from a health and safety perspective, it's not a bad system to operate. You do hear a lot of that. I think even the news operates 2 teams. So it's one of those things, though, that, look, just the employer probably needs to get agreement from employers around it if it's going to result in a change in hours or shift patterns from what's in the contract. But yeah, look, as a health and safety measure, it does, certainly provide an additional defence. It's not required necessarily, but it's another step employers can consider.
Okay. All right. I'm conscious that we're coming up to the end of our 30 minutes. Is there any do you have any tips that you can offer to employers who are maybe worried about, keeping up their obligations to their employers, to their employees through this period? Any kind of common concerns or themes you've been seeing?
Well, look, I think the concerns are all the ones we've really talked through, and those are the questions. And like I said, there are some where the answers are straightforward, and then there's areas, particularly around pay, where unfortunately the position is not really absolutely clear cut. I think the key thing really for employers is very much communicate. You do find that, and certainly what we saw last year was the employers who communicated best were the ones that had the least issues, irrespective of sometimes what type of approach they took as such. But as long as the employees understood what was going on and why an employer was doing what they were doing or doing what they were proposing to do, they tended to get the best response and the best engagement. So that would be probably the big one. And I think in part going along with that, wherever you can, and it may not always be practicable, stay in touch and actually speak to the employees through the lockdown, because again, FaceTime, if you can manage that, or even just calling and talking through what's going on, is one of those things that also tended to make things much less acrimonious at times, because employers are going to have to make decisions or take stances during particularly lockdowns that employees may not necessarily agree with or think are fair, and sometimes employees will be right on that, plenty of times in fact. But if you're communicating and being very clear about what's going on and why you're doing it, I think you're always going to be in a better position. So that's the first thing. The second one, again, is where you can consult with staff. If decisions don't have to be made immediately, then it's always important, and particularly when you're looking at, say, restructuring, consultation is essential. So consultation will be important to keep in mind and do as much of as you can through the lockdown period.
Okay. Do you get the sense that employers have been navigating this fairly well?
Yeah, I think just the number of queries we're getting probably from both sides. It's not to say that there aren't employers who are still struggling with it, and you only have to read the news to see that there's still issues with certain employers, falling well short of the mark. But I do think that there is generally a sense of we've done this before. That's not to say there isn't concern about what this could mean, particularly if the lockdown carries on for much longer. But yeah, generally the sense we get is that, here we go again. We know how to work through this sort of process. And while there is an element of getting up to speed with the changing rules and announcements around the subsidy and so forth, I think, it has generally been better than particularly the first lockdown and subsequent ones.
Okay, cool. Well, thank you very much for your time. I really appreciate it. We have some more questions coming in, but we'll keep rolling them out as written answers, so we'll work through them as we go. Thanks very
Fantastic.
much.